So welcome everybody to the Civics Project. I'm Beth Ribet, the Director of Repair and the host of the Civics Project. And I'm really glad to welcome both the audience and our special guest today, Professor Kim Hai Pearson, who is the Professor of Law at Gonzaga University. Before we get to our substantive content, I want to begin with a brief land acknowledgement. Repair acknowledges the Gabrielina Tongva peoples as the traditional land caretakers of Tavalangar, the Los Angeles Basin and South Channel Islands. And we're grateful to have the opportunity to work for the Tarahatum, the indigenous peoples in this place. We pay our respects to Hanuk Fatam, the ancestors, Ahihiram, the elders, and Eohinkem, our relatives and relations, past, present, and emerging. I'm really delighted today to introduce Professor Kim Hai Pearson. Professor Pearson's current research and writing focuses on identity and children in international migration streams. So this includes trafficking of children, adoption of children, children who are seeking asylum and are traveling for that purpose, meaning children who are refugees, children who are fleeing natural disasters, and children who are immigrating for economic reasons. In the context of the United Nations Convention on the Rights of the Child, a legal framework exists for extending legal protection based on a child's identity. So combining research on implementing the Convention on the Rights of the Child's legal principles in alignment with children's identities may provide significant interventions in cases of violence and oppression of children. Professor Pearson's expertise also includes contracts, law and sexuality, alternative dispute resolution, and wills and trusts. In her earlier work, her scholarship focused on the impact of identity classification for domestic family law purposes, including unfair outcomes for racial, religious, and sexual minority families. Her work is informed by her practice in a family law firm, by critical literary theory, and by non-advocacy research and writing at the Williams Institute at UCLA. Professor Pearson has delivered a Neil Gotanda lecture at Berkeley Law and presented nationally and internationally on her scholarship, and you can find her scholarship in the Yale Journal of Law and Feminism, the University of California at Irvine Law Review, the Michigan Journal of Gender and Law, the Oxford Handbook on LGBT Divorce and Relationship Dissolution, and the Cambridge University Press's Feminist Judgments, Rewritten Opinions on Reproductive Rights. She held a law teaching fellowship at the Williams Institute, housed at UCLA Law School, where she taught law and sexuality, legal scholarship, and family law. She received her JD from the J. Reuben Clark School of Law at Brigham Young University, her MA in British and American Literature from the University of Utah, and her MST in International Human Rights Law at Oxford University. So again, it's my privilege and delight today to introduce Professor Kim Hai Pearson. So welcome, Professor Pearson, and I want to begin by thanking you again and by asking you to tell us a little about what rights exist for children in the United States legal system.
First of all, Beth, thank you so much for having me. It's such a delight to have this opportunity to chat with you, not only about my work, but because it's so important right now. To answer your question, what rights exist for children, it's always stunning to me how surprised people are when I say something really provocative like, as a formal matter, children really don't have rights in the US. The United States embraces what's called a protectionist or welfarist model that's really based on the relationship between a parent and a child as a means of mediating the relationship between the state and an individual. So in other words, we have some idea that children will become citizens, but until and unless they are, there are other adults in the sort of buffer zone helping them and protecting them as they assume their full rights. Almost all of the rights that we think of as concrete formal rights attach to parents and not children. So you have constitutional protection for raising a child, the right to have or to not have a child, to make decisions for children, that, you know, we might say that they don't have the developmental skills or the competency to make for themselves. So when we look at the laws generally governing children, there's this very interesting presumption that a parent will act in the best interest of the child unless proven otherwise. So we start out with the assumption that people are benign to children. And when we look at the suite of rights around children, a lot of these are found in the privacy protections of the 14th Amendment protection of, quote, our liberty, right? So this liberty/privacy protection means it's really, really hard to disrupt this notion that people have in the United States that parents have a fundamental right to the control and custody of their children. So at the very worst sort of end of the spectrum, people thought of their children as property, unpaid labor, indentured servants, where they could, you know, buy and sell the labor that their children could produce. At its best, when we see the laws come in to protect certain families, then we get the family's ability to pass on traditions, religion, culture, things that, you know, might not be mainstream, and the government might be trying to regulate them. But because of that privacy protection, families can pass those things on.
Thank you, really helpful. So to the extent that children have rights or sort of pre-rights that are vested in their parents, how are they protected and enforced? Or whether it's articulated as a right or not, how does the protection of children occur in the United States?
Again, this is from a very sort of adult first or centric point of view. And even if we assume that there are rights for children or that they should be treated differently because of a vulnerable or early developmental stage, we do have a few spaces in the law where we treat children differently. And so you can look at, say, criminal law. We have Romeo and Juliet statutes for young people who are having consensual sex, but are within a couple of years of age, so that you can avoid some of the harsh circumstances around, say, statutory rape charges. Prior to the ruling that came out just on April 22nd from the Supreme Court, in Jones v. Mississippi, sentencing for minor children was starting to lighten up. So we weren't really seeing life imprisonment with no possibility of parole for children, for now adults, but when they had committed their crimes, they were minor children. And so we're seeing a really hard shift away from protecting children in that particular circumstance, which I will circle back to later because it sort of ties into this idea of why it's so critical for children to have rights and not for everything to be centered around obligations and duties to protect children. In family law, there's the custody preference. At a certain point, in most states, children can assert their own preference, and they can typically either speak in camera. That just means that they're with a judge and not in front of their parents, and or they have an evaluator, some usually a mental health provider or some other kind of child advocate, and they can say what it is that they would prefer. But of course, this is less of a right and more of an exception to the general rule, which is that children should not be in family court, and that it's about the parents figuring out what the best interests of the child are. And finally, the other few spaces where we have room for children to assert rights, minor children seeking an abortion can get one with either parental consent or a judicial bypass. And that just means that if they're afraid to tell their parents, they can seek intervention from a court and get permission to have one. And the same thing for underage marriage. Now, for immigration law, we have the Flores Settlement Agreement, but again, not so much a right as a duty that's imposed on government officials to not hold children over 5 days in a detention center. Of course, in 2018, the Trump administration tried to undo that and keep children there for 20 days plus. So when you have exceptions and special categories and tests and things like that to sort of acknowledge children's special circumstances, that is very different from having a suite of rights.
Thank you. Raises many other questions, but I'll turn a little bit to the subject of child welfare. One of the concepts that most of us have heard with some frequency is the idea of courts considering the best interests of a child. And I'm wondering if you can tell us a little bit more about that concept. What does it tend to mean in the United States?
Oh, that's a really good question and an excellent distinction, because the best interests of the child in the United States is very different from the way it's perceived internationally. So for the United States, we don't have a single, stable, fixed definition of the best interests of a child. And part of this comes from the United States roots in individualism. So every time a child goes up to bar, and that just means in front of a court or when we're considering an individual child, we want to consider that child's particular circumstances. So what ends up happening is you get a set of factors that people can take into consideration when they're making decisions about a child. And at least for the US, all of the states have a varying set of factors that they go through. But as a general rule, no one factor can be dispositive. And that means the whole decision cannot hinge on just one factor. You're required to look at the set of factors. So an example would be the easiest one, right? It's race. And it's also the most complex, right? So on its face, it's very easy. You say, you cannot look at race as a dispositive factor. So if you say have an Asian child and two sets of parents who both want rights to the child, one is white and one is Asian, you may not say, because the child is Asian and these parents are Asian, we will therefore move this child to the Asian parents. So that's an example of a factor being dispositive. But most of the factors are similar across sort of welfarist points. And that means usually courts will look at the child's relationship to family members, what the parent's capacity is to provide for the child's physical needs. So home, food, medical care, education. And then a small number of states prioritize mental and physical health needs for the child and the mental and physical health capacity of the parents. So it's a very interesting move that some states, and it's a very small number, it's 9 out of 50, that are moving toward accounting for the child's mental and emotional well-being. And on the negative side of this, any instances of violence against a child, violence in front of a child, intimate partner violence that the child is in any way aware of, those things can also be taken into account. And as far as children in the system who are identified as Native or part of Alaskan Natives or tribal communities, we have the Indian Child Welfare Act, and that's really a procedural speed bump. And this just gives all of the authorities making decisions about this child a little bit of space and time to consider the child's tribal relationships the child's culture and values. So it doesn't mean that the case gets removed automatically to, say, a tribal court. But if a child needs out-of-home care, then efforts are, in the best circumstances, supposed to be made to help the child maintain tribal relationships. So it's really about valuing that relationship.
We have a question in the Zoom chat from Alicia, who has asked, is there anything in children's rights law regarding children of African descent?
That is an excellent question, and something that I've thought a lot about, because not that long ago, the National Association of Black Social Workers published something like maybe like a statement, but it felt very much like a manifesto saying children of African American descent should be entitled to appreciate and learn about culture and values and what it means to grow up in America and to deal with ongoing racism. Unfortunately, unlike the ICWA, which is a piece of legislation that has turned into law,
this is the Indian Child Welfare Act?
Yes, I'm sorry.
Okay. That's okay.
Like, I'm just like, oh yeah, the ICWA. So I think as far as children of African descent go, this has been in a lot of ways sort of a third rail, meaning that people are really reluctant to talk about this. And it makes a lot of people uncomfortable because you're talking about acknowledging racism, these structural issues. And when we think about the movement en masse of brown and Black children from brown and Black parents, it's really hard to hold that in your mind at the macro level, and then also look at an individual child where it's that child's needs, right? So for example, if you're, say, a court officer and you're making a decision about this child and everything seems okay, and you're like, you know what, it's better that this child goes to these parents regardless of race rather than, you know, any other number of alternatives, including things like foster care, group homes, something like that, right? So that one instance, it might make sense. But then when you look at the aggregate and you see a mass movement of multiple children, then you're looking at an individual answer for a large structural problem. And those individual parents may not, they're probably not bad actors. In fact, they're probably really good actors and they want to open their homes. But at the same time, it obscures the fact that brown and Black parents want to keep their children and wish that they had the means and the ability to be rightful parents to their children. So it's very complex, but at the same time, it's some of the main issues, you know, it's sort of hitting on those main issues that really drive people into these divisive positions that, you know, we're seeing playing out on the news.
Indeed, thank you. Tell us more about how the U.S. approach to children's rights differs when you compare the United States to other nations, whether for better or worse or just a difference.
Well, there's a huge difference, and there's a huge variety of ways in which other countries deal with children. So rather than sort of cherry picking the best and worst of all and sort of figuring out where the US is, I think a better way, at least from my understanding, is to think about conceptions of childhood as both an international law matter and as a domestic US legal matter. So internationally, we have something called the Convention on the Rights of the Child. And every country, and this is always so troubling, people say, even Somalia, as though, you know, it's like less than desirable or something. Or anyway, the Convention on the Rights of the Child, or the CRC, has been ratified by 193 countries and not the US. So the US has signed on, and we have signed and ratified 2 of the optional protocols, which means we have committed to fighting child soldiers and sex trafficking, labor trafficking, basically any kind of trafficking of children. But we signed and ratified both of those with the express condition that we do not ratify the main convention. The sticking point on the main convention is that children are rights holders in their own selves. So separate from parents, separate from the state, they have their own set of rights. And if you have rights, that means that on the other side of this, you have duty bearers. So if you're a rights holder and somebody infringes, then you look to your duty bearer and you say, please enforce or please redress the ways in which my rights have been violated. So that's one aspect of it. But the even more important aspect of the CRC's conception of children is if you implement it well, this idea that for everything that your country is doing, it will take children's rights into consideration. You can actually look at large-scale problems and deploy multiple agencies and institutions and problem solvers to address a structural problem from multiple angles. So, for example, say that you want to fight childhood poverty. And in the world, living on $1.90 a day or less is considered extreme poverty. So there are about 13 million kids as of 2016 in the US who were living in extreme poverty. And the numbers vary for other countries, but giving a child in extreme poverty would actually, you'd give it to the child's parent or to the state if the child's in foster care or group home. If you give that child assistance in the form of money and resources, it's going to help for a while, right? Because, you know, if you're hungry, it's really, really great to eat. But if you compare that to the way in which a country that can implement and has the political will to actually protect children and their rights, then you can see multiple groups working together to actually get at the roots of extreme poverty. So instead of targeting this child, they're targeting the problems, the conditions that create extreme poverty. So if that means changing policies around maternal care, changing policies around training and workforce reentry and things like that, where it's really addressing all of the ways in which the world has an impact on that child in ways that are sort of exaggerated, or not exaggerated, but more impactful because the child has less power to act as an adult.
Okay. So I'm thinking about how to kind of encapsulate that for those of us who don't have your amazing expertise in this area. And one of the things that's striking me as I'm listening is, you know, hearing basically that children have less ability in the United States to assert their own rights, and that the intention to keep the US legal system that way appears to be the primary sticking point preventing the United States from signing on to or from ratifying the full Convention on the Rights of the Child. Am I about right there?
Yes, I'm so sorry.
No, you're great. These are dense concepts. So
all this jargon. Let me give you an example. So
sure.
Say that the US ratified the CRC and said, we are going to implement this and we are going to protect children's rights. So under the CRC, a child has a right to live in safety. So instead of going to school with the threat of, say, a mass shooter, the government would be responsible. They would be duty bearers for figuring out a way for kids to go to school safely.
Okay, very helpful. Eric and Sharon in the chat are asking, what is the rationale behind why the US doesn't want to consider children rights holders? Why?
So of the big fears, and this goes back to the right to have a child being located in the privacy, the penumbra of the 14th Amendment liberty right, is that there is a fear that children will sue parents, or that the government will be able to step in and say, you're being a bad parent, without proving that, first a parent has to be proven unfit before the state can intervene. There are a lot of, I don't know if it's politically sensitive or not, but there are certainly parents who don't want their children to receive, say, vaccines or medical care or sex education in school, or to be in a classroom with books about gay marriage, right? So separating out this idea that if a parent has control of a child, then that child has no set of rights. Where the huge misunderstanding comes is simply because a child has rights does not mean that the parents don't have rights. It's not a zero-sum game. It's also not a contest of wills between the two groups. In the Convention for the Rights of the Child, one of the main priorities is protecting the child's rights to a relationship with that child's parents and community.
So that's really interesting to contemplate, just thinking of the US as being afraid that children are going to start suing in ways that will somehow compromise parental rights. Really interesting. You'd mentioned a couple of times the influence of race and racism in some of the legal and social service spheres that children and their families navigate. I'm wondering if you can just elaborate a little bit more about that. Why is race part of the landscape of children's rights?
So the danger of thinking through how race has impacted and shapes these interactions with children and families is that all families are different, and the use of these stereotypes and generalizations at the same time, they're telling us something, right? So I really admire Dorothy Roberts' works because she's identifying how the system will take aim at African-American families and from multiple angles really set up all of the conditions for an inevitable failure and then blame the individuals for failing. So it's like you create the problem and create all the conditions for it, and then you blame people for what is inevitable. The other thing about rights and the way that race works is that it's unclear how you can separate. And what I mean by that is a lot of people think that children have a right to be educated from K through 12. So there's a requirement, right? We want to educate children, but having a right to it is different from the state obligating parents to send their children to school. So if you think about, say, dreamers who want to say, I should have a right to a public education, like the people I've grown up with. I was an infant when I came to America. I didn't come here of my own volition. Now I'm here. I should be able to go to school. And we say, you have no right to that. Now take that particular instance and that ruling, and all of a sudden you have a way in which this speaks to brown and Black immigrants, to people who might be vulnerable. Part of the difficulty around recognizing rights is then you do have to recognize duty bearers, and sometimes people, they don't want to support other people and other people's children, right? This sort of, these are my children and I can do what I want and protect them while letting other children suffer or receive fewer things. And it just so happens that it all seems to line up with race or income is another way in which there is no way to think about family law without thinking about race.
Really interesting. I want to be sure that the audience, our lay audience in particular, is sort of wrapping ourselves around the concept of a duty bearer. So I'm wondering if you can just, in simple terms, tell us a little bit more about what exactly does being a duty bearer mean?
So we have all different kinds of relationships, and some are legally recognized. And if they are, you get benefits, but you also get burdens. So a parent has a fiduciary relationship to a child, meaning the parent is supposed to act in the child's best interest and do for the child as a parent would want done to him or herself, right? So it's like a trustee's relationship to a beneficiary, somebody who's put in charge to really look out for somebody. But a duty bearer is someone or some institution that has a legal responsibility, a legal duty to protect this particular right. So going back to the example of theoretically, if the US were to recognize children's rights and say, you have a right to live in a clean environment with clean water. So think of the children in, say, Flint, Michigan. Who would the duty bearers be that would then make sure that those children get fresh water that's clean, and the children could then sue them on their own account, which is different from what happens. And the same with the guns, right? If you say, I don't want guns in schools, we can say, oh, well, maybe we'll look at the First Amendment, but that's all adult-centric and adult rights-centric. Whereas if you have duty bearers to ensure that when children go to school, they don't have to worry about lockdowns and shootings, then you look to your duty bearers. Well, who owes a responsibility to children so that they can have a safe school? Does that help clear things up?
It does. What I'm hearing is that when a person has rights, that gives the government more responsibility to protect the rights. So one of the things that I'm hearing is implicated in the US resistance to adopting the children's rights standards that we see in a lot of parts of the world is not wanting those responsibilities, not wanting the responsibility for not having children live in poverty or drink contaminated water, or making, sure that not just parents are obligated to send their children to school, but that kids have more rights to, well-functioning education. So really, really interesting. Thank you. That was helpful.
Excellent point, Beth. That ties so nicely into a lot of work that's being done on the privatized family. So I don't know if you've looked at Maxine Eichner's work
I
on
haven't.
the free market family, and Claire, oh, I think she's at Fordham, Claire Huntington. She's done a ton of work on how families are set up to fail, and not just families of color, but families in general, because of the system of privatized family does everything for itself.
Gotcha. So by privatized family, we mean that kind of almost every responsibility for a child's well-being is on the parents rather than on the state.
Right. And it's been thrown into stark relief in really surprising ways during the pandemic, where you're seeing who gets the higher burden for educating children, for doing child care, elder care, all while working. And certainly another stunning statistic I saw was the children that are kept out of schools versus the children that have been in school for quite a long time during the pandemic. So we're talking private schools, nicer schools, more resourced schools. They're predominantly white schools, and the children who have been kept home or in schools virtually, they're almost all children of color. So the percentages are just really, really out of proportion.
That's really interesting to hear. I'm wondering if you can tell us more about your own scholarship. I know you've been doing work of late in the field of international adoptions.
Sure. So again, this ties back to this hugely problematic issue of the mass movement of children from the global South and Asia to countries in the global North. So in other words, it's over time, we're seeing more and more children of color moving to white families. And, you know, it tells us something really important about race. It tells us something incredibly important about how we value children and the various identities that get sort of labeled, right? These characterizations and categories that we drop children into, so that all of this transferring of children is not only okay, but is sort of laudatory, right? So this is also connected to this idea of choice. It's very much like online dating. Prospective parents can identify race, gender, ability levels, age, all sorts of things for a prospective child, which, you know, you might say, well, it's okay in dating, and, you know, maybe dating is like predicting who you might have a child with, so how is that different? Or some narratives you hear are, well, it's good for you to know your limitations ahead of time so that somebody else who could provide a better, more loving home could, you know, take the child that you don't want, or what have you. So all of this happens in sort of a free market, supposedly free market, internationally. And then domestically, you also have various channels for moving children around. And it's sort of problematic, right? Because much like Laura Briggs, who's one of my favorite scholars in this area, I'm not against adoption. I'm actually for adoption, but I am an anti-subordinationist. So getting those things together and really thinking through the kinds of regulations that we have, how we formulate our best interest set of factors. Do we actually value a child's identity? So we already know, we've had multiple cases, large scale cases, longitudinal studies that show if you move children from homes and communities and they have no cultural touchstone, and they are transracially or transculturally, just, they don't belong, they don't fit in the same way, the outcomes for them are incredibly bad, but we still do it.
What
And
sort of outcomes?
Right. So higher suicide, depression, more substance abuse, risky behavior. So when we talk outcomes, we usually talk in developmental outcomes. There's a list of things because we're a welfarist country, right? We think very carefully about tracking these things. So we have no excuse. We know it's bad, right? So from Indian boarding schools to any kind of mass movement of children, the orphan trains, we have ways in which children are, quote, saved from their own cultures. All of this we know is going to lead to bad outcomes generally. So people might say, oh, but I know an adoptee and they're so happy and they love their family. And it's like, well, right, but that's the individual, not the macro. So macro, micro.
So the numbers base, it's not that every child has a negative experience, it's that the proportions of negative outcomes are really heavily weighted towards those that are taken out of their own cultural context.
Right.
Okay.
Perfect. It's disproportionate.
I wanted to ask you if you were to sort of choose the top maybe 2 or 3 things that you would want to change in US policy, you know, with the aim of most improving safety or health or opportunities or rights available to children in the US or entering the US, what would be sort of your top priorities? What would you fix or change or introduce?
The first thing I would fix is the right to have rights. That's from Hannah Arendt. And she was writing about refugees who are not fully seen as citizens of their new state, but they can't forget their former state and they can't fully assimilate. And when I think about the children who are most in need of rights and most in need of protection, they're the ones that are unseen by any state. So this is different from being stateless. You might be, say, a refugee, but if you're moving in either overland or water migration, and no one is tracking you through multiple borders, you are so far beyond stateless. It's as though you don't exist. And so simply the right to be seen as human and have rights is a huge beginning. Then I would look at relationship rights, moral rights, and the biggest issue facing children is probably poverty.
When you say relationship and rights and moral rights, what are those?
Relationship rights are valuing the relationships that the child has with not only the parents, but multiple people, culture, what have you. So recognizing that a child may be young and at different stages in developing, but that doesn't mean that those feelings and relationships aren't as real to that child as they would be to an adult.
Gotcha. And I'm just blanking now on the second category.
Moral rights.
Moral rights. So what are moral rights for children?
So moral rights are, it's this really fantastic concept from James Dwyer, which basically says we need to value children as fully realized human beings. So just as we might say it's cruel and inhumane to tie a dog to the back end of a car and drive, that's morally wrong. And we say we have, some moral sense that there is value to that dog's life, and to treat a dog that way would be cruel and tells us that we are immoral actors. So children have moral rights and adults don't always recognize them. And so this idea that a child could be valued simply for being a child and fully realized as somebody with value would completely change the way in which we function and create rules for children.
Mhm. Really interesting. Thank you. What's in the way? So if we all here agreed, wow, that sounds great. I think children should have moral rights. I think they should have relationship rights, and I think they should have the right to have rights. What would we have to overcome in order to make those changes in policy?
Oh, years and years and years of history. This really sticky notion that parents know best for their children and should always be in charge. This idea of control and custody. And it's less about stewardship and care and nurture. And I'm not talking about specific parents. I'm talking about the legal formulation. So the right to have a child, the right to raise a child as you see fit, right? Those are all not only parent-centric, but really configuring the child as less of a subject, more of an object. So you'd have to get over this idea that all interference from the government is bad, which is really hard because the government has acted very badly to some families. So, but one of my favorite colleagues always says, the law protects those who need it the least. Yeah, so maybe the biggest thing after that really sticky notion around individual rights would be the lack of political will to invest in children like we do other things like, oh, I don't know, the military. Yeah, I'm just throwing that out there. But in all reality, we really don't invest in children like they are a soon to be scarce resource. Because birth rates are falling everywhere. I don't know if you've read Empty Planet, but that was a really like compelling argument that if children become as scarce as it looks like they will be based on the declining birth rates in every country, these sharp divides around race and thinking about children as resources will only become sharper
and more urgent. Gotcha. Thank you. Wow. Well, for our listeners who would like to keep learning, do you have a recommendation of where they can start reading? Oh, Bernita in the chat is asking, can you repeat what you were saying about being parent-centric? Maybe what is that exactly?
Oh, that's where the rights focus on protecting a parent's right to do things without intervention from the state. So it's a very state suspicious stance as compared to the state being the provider of resources and the duty bearers to the children to make sure that they get their rights.
So just as an example, an example of a parent-centric policy would be one which protects the rights of parents to raise their children in a particular religion without interference from the state. Whereas maybe a child-centric policy would focus on a child getting to practice or not practice religions of their choice. Would that be a good example, maybe?
Well, to sharpen it a little bit,
Please.
a parent-centric, I don't want to call it a custom, but we've seen cases where parents who have religious or personal reasons for denying a child medical care, those decisions can be upheld by courts to the point of, in one case, a child was visually impaired in one eye, but because the child didn't die, it was just an injury to the child, then it was fine. Now, that's about observing the parents' rights at the expense of the child. Now, not every case is that extreme. And I'm not saying that all parents who don't believe in various kinds of medical care are bad parents.
Right.
It's just, it's a really, really easy example so that you can see the tension and understand what it means to be a parent-centric legal system. So to take the same example and try to think through, well, how would you take the child's rights into account without setting it up as a zero-sum game where either the parents have rights or the child has rights? That's a completely different problem, right? And so that's where you can see that resistance to changing the sticky notion of parents having control and the care and custody of their children.
Mm-hmm. Or at least some parents.
Well, right.
Mm-hmm. Thank you. That was great. So I had just asked you if you had a book recommendation, a reading recommendation to share with our audience, or more than one.
Okay, so there are just so many great resources out there. I will limit myself to 6, but wish I could tell you more like 25. So number 1 would be Shattered Bonds by Dorothy Roberts. Number 2, Taking Children by Laura Briggs. Number 3, The Relationship Rights of Children by James Dwyer. Number 4, Family Values, The Ethics of Parent-Child Relationships by Harry Brighouse and Adam Swift. Number 5, The Children and Politics of Cultural Belonging by Alice Hurst. And 6, Pricing the Priceless Child, The Changing Social Value of Children by Viviana Selitzer.
Thank you. Well, that certainly gives folks a great foundation to start learning more. So I want to really enthusiastically thank Professor Pearson for sharing some of your knowledge today. And I will invite our listening and Zoom audience to join us next week for our curriculum on family and medical leave. And then on May 16th, we'll be back to talk about Veterans Affairs. On May 23rd, we're featuring Deborah Dorfman, a very seasoned disability rights attorney who'll be talking about disability rights with us. And then on April 30th, we'll be focusing on the census, and we're really delighted to be hosting Dr. Janine Abrams-McLean from Fair Count in Georgia. Fair Count and Fair Fighter are collaborating organizations. And many of you know of Fair Fight, which is run by Dr. Abrams-McLean's sister, Stacey Abrams. So again, we're really excited to host Dr. Abrams-McLean to tell us a little bit more about the census. And in addition, our film screening for this month is, what is it? United States of Conspiracy. And we will be doing that screening on the, 26th of May. So I hope many of you will join us for those. And if you register today in Zoom, you'll get a link to find more events. If you are listening, you'll see that link as well in the description of this episode. So thank you so much, everybody, for joining us today for our conversation with Professor Kim Hai Pearson about children's rights and child welfare.
Thank you, Beth.